Hi, if anyone's there, this is Laura Evans. I am the transcriber. I wasn't able to reply to the message.
Good morning and welcome to call participants along with their legal representatives. I would also like to welcome those members of the public and the press who are observing this hearing via the inquiry's live stream. This is the second preliminary hearing of the Brook House inquiry. Regrettably, we remain in a public health situation which necessitates this hearing being conducted virtually, as was the case with the first preliminary hearing. Again, I'm very grateful to the inquiry team and technicians working behind the scenes to facilitate this hearing and to ensure its smooth running. On that note, can I please briefly remind all those participating to keep in mind the housekeeping guidance issued by the inquiry team. Please ensure that you are on mute unless invited to address the hearing by myself or counsel to inquiry, Ms. Catherine McGahey, Queen's Counsel. I will shortly turn to Ms McGahey to provide a progress update on the inquiry's work, after which I will hear submissions from core participants or their legal representatives. Before I hand over to Ms McGahey, I would like to make a few brief comments. Firstly, I would like to take this opportunity to update that the inquiry has in place a free, independent and confidential witness support service from crisis support charity Hestia to support witnesses through the process of giving evidence to the inquiry. Please do visit the Witness Support tab on the inquiry's website for details, where information is provided in a number of languages about the support they offer and how you can contact them. Today's hearing was convened to allow adequate time to hear submissions in relation to the inquiry's scope. I'm grateful to core participants for the written submissions I've received on my interpretation of the inquiry's terms of reference and scope. I have read all of these submissions in full, along with the note from counsel to the inquiry, which was sent to core participants on the 7th of December 2020. Today's hearing will allow me the opportunity to listen to any supplementary oral submissions, and I will do so with care. To the extent that it may be helpful to core participants and their legal representatives, I can provide an initial steer regarding the matters upon which I'm particularly interested to hear their views. As I set out in my opening statement in April and at the first preliminary hearing in September, it is my view that this inquiry must build upon and add to the findings of previous inquiries and investigations into events at Brook House. Again, as I've previously outlined, this inquiry's fundamental role is to address the questions of what was happening in Brook House between April and August 2017, and how can such events be prevented. I will also say again that it is my view that the principal focus of the inquiry will be the treatment and mistreatment of detainees once they had arrived at Brook House. However, I do also want to reiterate my view that any recommendations made as a result of this inquiry must be capable of bringing about change to prevent mistreatment in IRCs now and in the future. They therefore should not be recommendations that only have relevance to the specific time and place of the mistreatment shown on Panorama. I therefore consider that the determination I will reach on scope following this hearing will answer the question of the degree to which events or systems outside Brook House and before or after April to August 2017 are relevant to answering the central question for this inquiry: what happened and how can it be prevented in future? I will of course listen carefully to each of the submissions to follow, but suggest that there will be of particular assistance if that overall question can be kept clearly in mind. That concludes my introductory comments. Ms McGahey, I will now turn to you and ask that you please provide an update on the inquiry's progress.
Certainly, ma'am. I'm dealing first with representation. I'm counsel to the inquiry. Working with me is a team of counsel, Ms. Saoirse Townsend, Ms. Jo Moore, and a recent addition to the team, Mr. Paul Livingston. Mr. Livingston has joined us. Ms. Townsend is due to leave us shortly on maternity leave, and we offer her our very best wishes and look forward to seeing her back later next year. The representation of the core participants today is for MA and the Reverend Ward, Miss Stephanie Harrison, Queen's Counsel, with Mr. Alex Goodman. For SRKK and Medical Justice, Ms. Harrison with Ms. Shushin Liu and Ms. Laura Perfumo. For IA, Ms. Harrison with Mr. Zainul Jafferji. For BB and Gatwick Detainees Welfare Group, my learned friend Mr. Odogwu and Ms. Jessie Nichols. For the Home Office, Mr. Julian Blake and Ms. Emily Wilsden. For G4S, Mr. Andrew Sharland, Queen's Counsel, and Mr. Daniel Eisenberg. For the BBC, Mr. Jude Bunting. For HMP, Ms. Claire Dobbin. And for IMB, Mr. Jonathan Dixie. I'd like to provide core participants and the public with a brief update on the work of the inquiry since the last preliminary hearing in September. Turning first to documentary evidence, the inquiry has now received over 24,000 documents, not all of which will be relevant to the inquiry's work. No firm view on the relevance of some of the material can be reached until the chair has finally just determined the scope of the inquiry. But the team of lawyers who are assessing the material are applying a generous test of relevance to ensure that nothing potentially relevant is missed. A substantial tranche of material has now been redacted in preparation for disclosure to core participants. Redaction by the inquiry involves the substitution of ciphers for the names of individuals formerly detained and the blanking out of irrelevant personal or identifying information, including things like direct dial telephone numbers or medical or family information that's of no potential relevance to any allegation of mistreatment. A tranche of redacted material has very recently been sent to the owners of the documents of that material so that they have the chance to apply for any further redactions to be made, for example, on grounds of legal professional privilege, or for there to be changes made in the redactions before onward disclosure to core participants. A disclosure platform exists and is ready for use. The inquiry intends to use an EPIC relativity platform, and the inquiry expects to be able to grant access to core participants to that platform and supply the first tranche of disclosure early in the new year. This tranche of material will consist of documents coming principally from G4S and the Home Office. The inquiry has asked for additional material from the BBC, among others. The Home Office has supplied the inquiry with the personal immigration files of a number of detainees, and the inquiry is in discussions with the Home Office about disclosure of this material. It's necessary for us to work with the Home Office to ensure that further disclosure of these immigration files is more manageable. Some of the files are enormous, some may go back years, and some clearly contain material that's not going to be relevant. We intend absolutely no criticism whatsoever of the Home Office in this respect. We're being given very comprehensive disclosure, but it's clear that a lot of the material is material that will not, whatever the scope of the inquiry, be relevant. It's very important for the inquiry to ensure that it has every Home Office immigration record that may shed light on the mistreatment of any detainee at Brook House between April and August 2017. But it's also important that the inquiry's reviewers who are going through and assessing this material are not overwhelmed by having to deal with thousands of irrelevant documents. So that's a work in progress, but we do have the complete immigration files for a number of detainees already. Turning now to witnesses. As the core participants know, the inquiry's intention is for its own lawyers to take statements from witnesses. We had hoped that it would be possible to meet witnesses face to face. And realistically, we've now had to accept that in order to make progress, we are going to have to use video conferencing for a lot of these interviews. The inquiry is now making arrangements to start meetings with witnesses in the week beginning the 18th of January next year. The tracing of formerly detained individuals is also continuing. The inquiry would be very grateful for assistance, whether from individual core participants or from NGO core participants, in identifying any other people who were detained at Brook House between April and August 2017 and encouraging them to come forward. As core participants are aware, the inquiry does not intend to use powers of compulsion to require former detainees to come to give evidence, but we really do urge their cooperation. Next, experts. As core participants are already aware, the inquiry has appointed Professor Mary Bosworth and Dr. James Hard to provide expert evidence. Professor Bosworth will focus on the culture and management arrangements at Brook House, including issues relevant to race, and Dr. Hard on medical issues. Their instructions will be finalised after today's hearing and once the chair has ruled on the scope. Lastly, on undertakings, as again core participants know, in order to avoid the risk of witnesses declining to answer for fear of self-incrimination, the chair has requested undertakings from both the Attorney General and the Home Secretary. The attorney has invited submissions from core participants before making a decision. The deadline for those submissions has now passed, and the inquiry is waiting for for decisions from both the attorney and the Home Secretary. The main issue to be considered today is that of the scope of the inquiry. The inquiry has received submissions on the issue from the majority of core participants. The terms of reference are obviously the starting point for any consideration of scope. They make clear that the inquiry is to investigate mistreatment shown on Panorama, and more broadly to investigate any mistreatment that occurred at Brook House between April and August 2017 that amounts to mistreatment within the definition of Article 3 of the European Convention on Human Rights. There is a substantial amount of common ground in the submissions made by the core participants. In particular, there does appear to be a general agreement with the proposition put forward by BB and the Gatwick Detainees Welfare Group that an effective inquiry needs to remain flexible and go where the evidence takes it. And the core participants also recognise that the evidence may lead the inquiry to consideration of practices, policies and procedures applicable at national level and not just at Brook House. And that's something that the Chair has recognised at an earlier stage and reiterated today. The key difference between the core participants appears to lie in the approach that they contend should be taken to issues arising outside Brook House and also outside the terms of the period of the terms of reference. And there are essentially two competing contentions. Firstly, that the inquiry should examine wider issues, for example, breaches by the Home Office or its contractors of detention policy in other immigration removal centres, or the correctness of the initial decision to detain an individual, because they form the background to and may be relevant to an understanding of the underlying causes of the mistreatment that subsequently occurred. The second approach is that the entire inquiry starting point should be the investigation of individual instances of mistreatment in the relevant period, and the inquiry should then track back from those instances to find the underlying cause. The submissions of MA, the Reverend Ward, Medical Justice, SR, KK, BB, and Gatwick Detainees Welfare Group are largely consistent. They submit that there's nothing in the terms of reference that limits the consideration of methods, practices, and managements to those operated locally at Brook House. Secondly, they say that an effective investigation contemplates the consideration of law, policy, practice, and institutional culture that cannot be limited to Brook House. And they submit that where it is relevant, the inquiry should investigate national methods, policies, and practices. And while obviously it's a matter for the Chair, it appears to me that that's not a contentious submission that does appear to be accepted. Thirdly, the inquiry should investigate not simply local or managerial causes for what went wrong, but wider policy causes. And again, certainly to some extent that appears to be accepted. Fourthly, and this is by way of example of the third category, the inquiry should investigate breaches by the Home Office and its contractor of Rules 34 and 35 of the detention centre rules over many years, in order properly to understand the background, the culture, and therefore the underlying causes for any failings at Brook House. And finally, the inquiry should investigate the connection between the Home Office's power to detain for long and indefinite periods and any mistreatment. More specifically, Medical Justice, SR and KK submit that the inquiry should investigate, firstly, the attitude that the Home Office and its contractors have taken to external scrutiny of their conduct, both at Brook House and elsewhere. Secondly, what they term the Home Office's persistent non-compliance over the years with its own detention policies and procedures and with equality duties. And thirdly, the repeated patterns of mistreatment amounting to treatment of an Article 3 threshold that they say has taken place at Brook House nearly a decade, or had taken place for nearly a decade, up to 2017. Both MA and BB have previously submitted lengthy and detailed lists of issues that they contend the Chair should adopt, and those lists have been shared with core participants. The Home Office supports the Chair's expressed intention to focus mainly on the treatment and mistreatment of detainees following their arrival at Brook House. The Home Office submission is firstly that the inquiry should concentrate on those issues that flow directly from the investigation into identified mistreatment. Secondly, they say the mistreatment in question is defined in the terms of reference and includes only incidents that occurred between April and August 2017. The Home Office agrees with the Chair's initial view that it is not for the current inquiry to consider immigration policy more widely. The Home Office supports the Chair's list of issues, which was set out in her note of the 14th of August 2020, but submits that that list should be kept under review and that issues that turn out to be irrelevant should be discarded. G4S, in their submissions, emphasise that terms of reference permit the inquiry to investigate only any mistreatment that reaches the high threshold of a breach of Article 3. G4S, like the Home Office, submit that the starting point must be the consideration of individual instances of alleged mistreatment. G4S agree that the inquiry should examine any changes to policies and procedures made since August 2017, since such examination is necessary to inform any recommendations that the Chair may make. G4S do contend, however, that the inquiry should consider the adequacy of those changes, I'm quoting from their submissions, by reference to what the inquiry considers is appropriate to remedy any defects and not pursuant to an additional assessment of their effectiveness in practice. And my suggestion is that the chair of the inquiry might be helped by further submissions on this issue from G4S particularly, because it's not entirely clear to the counsel to the inquiry, to our team, how the inquiry should assess whether a change is appropriate to remedy any defects without looking at whether it's actually worked in practice. The Independent Monitoring Board and Her Majesty's Inspectorate of Prisons have made no substantive submissions on scope, and no submissions have been received from the BBC. I'll now invite core participants to make submissions, and my suggestion is that we should follow the order. First, Ms Harrison, Queen's Counsel, then Mr Odogwu, then Mr Blake, Mr Sharland, Queen's Counsel, Mr Bunting, Ms Dobbin, Mr Dixie. So may I invite Ms Harrison, Queen's Counsel, to make submissions on behalf of her clients.
Thank you, Ms McGahey. Ms Harrison?
Good morning. I don't know if you can hear me.
We can indeed hear you. We can't see you.
That's because I'm being told that the host has stopped, is preventing me from appearing.
Okay, we'll see if we can remedy that. My apologies. Do bear with us a moment. Thank you.
There we go. Thank you.
Thank you.
Can I just say before I start my submissions on scope that we're very grateful for the update on the steps that the inquiry has taken in terms of witness gathering and the disclosure platform. We have put in writing our concerns about the ongoing delay in those basic steps being taken. I appreciate that the inquiry wishes to consider those matters outside of this public hearing, but we do think it's important to put on record our ongoing concern about those matters, and in particular our concern about the viability of hearings in June. We mark that now because obviously it may be something that has to be the subject of further written representations to the inquiry, but we do have serious concerns about whether that can be achieved in accordance with the obligations to ensure that the inquiry is effective. And we do within that have ongoing concerns about our ability as core participants to effectively participate because of the way in which the inquiry is funding our work and the way in which it is considering our requests to take and to undertake the tasks that we think are important for advancing our clients' interests and assisting the inquiry in carrying out its important functions.
Thank you for your comments. And as you say, we have undertaken to deal with some of these issues in correspondence, and hopefully the update given by Ms McGahey this morning has also provided some more detail. So thank you, but I think it would be helpful if we could move on to the substance of scope.
Sure.
Thank you.
It does seem to us as core participants that there is here a potential fundamental misunderstanding about the term mistreatment that appears to be informing the submissions, certainly of the Home Office and G4S. And I think it's important to start from what do the core participants identify as the mistreatment that falls within the Article 3 obligation. It is absolutely apparent from the judgment of Mrs. Justice May, which is the context for this inquiry having been established, that mistreatment is not in any way, shape or form limited to the actual infliction of physical violence or assaults on individuals. If you go to paragraph 24 of that judgment, you will see set out in some detail in Mr. M.A.'s case, the extent of the factors that were relied upon by him as the basis for both individually and cumulatively the claim that he was subject to inhuman and degrading treatment. And if you have that document in front of you, I'm sure you're very familiar with it, you'll see that the first two factors that were relied upon are the decision to detain him in circumstances where we say that was clearly in breach of the Secretary of State's policy, because he fell fairly and squarely within the notion within the definition of an adult at risk, a person at particular risk of harm in detention. And he relied upon the wholesale failures of the safeguards to identify him as a vulnerable person, in particular rules 34 and 35 of the detention centre rules. Those failures, i.e. of policy and of safeguards, are not isolated to his case, nor isolated to Brook House. The evidence is clear, and insofar as this inquiry is going to build upon the pre-existing investigations, for example, from Mr. Shaw, you will see that those are in fact systemic issues and cannot be in any way seen as an aberration relating to this individual. That therefore means it's fairly and squarely within the inquiry's terms to need to look at both the operation, both the terms of and operation of the policy, which is a national policy and not obviously peculiar to Brook House. Likewise, with regard to the important safeguards in Rule 34 and 35. The consequences that were identified in MA's case of these systemic failures are at paragraph 5 and 6 of the judgment of Mrs. Justice May. Firstly, that there was a systemic and operational failure to identify, protect and monitor MA as a vulnerable detainee in breach of the positive duties arising from Article 3. There's reference there to the case of HA Nigeria, which is one of the 6 cases in which the domestic courts have identified a breach of Article 3, not because of actual physical mistreatment, but because of the decision, unlawful decision to detain, and the detention having severe impacts on the person's mental health, causing anguish and suffering sufficient to cross the Article 3 threshold. That's mistreatment under Article 3 of the Convention. Likewise, at paragraph 6 of MA, he relies upon the fact that his mental health condition was not properly assessed, that the measures that were in place did not effectively diagnose or provide treatment or management of his condition. And again, reference there is to a case of MD versus the Secretary of State for the Home Department, another case in which Article 3 was found to be breached as a result of the decision to detain and the impact of the detention and the conditions of detention. That was said in the context of MA's case to constitute a failure to recognise MA's vulnerability and to treat him accordingly, and this amounted to a breach of both the negative and positive requirements of Article 3. And so, starting from the premise, as we do from MA's facts, and there's no dispute between ourselves and the Home Office that you need to ground this inquiry in the individual experience of those who were subject to detention. In this context, I'm starting with Mr. MA. It's absolutely apparent that if you start from that premise, it is inevitable and intrinsic to his claim for an Article 3 breach that the decision to detain and to continue to detain and the conditions of detention are part and parcel of the grounds upon which he alleges an Article 3 breach in his case, because the consequences were such that he suffered a significant deterioration in his mental health. He experienced extreme suicidal ideation, and that treatment constitutes treatment falling over the threshold for a breach of Article 3. It's for this reason that when one looks at Mrs. Justice May's actual reasoning for concluding that a full public inquiry was necessary, she identified at paragraph 61, as we say is correct, you're going to start from the alleged substantive breaches of the article, and that's what we do when we've identified those factors, in addition to the physical ill treatment that MA was subject to, that constitute the breach of Article 3 in this case. You will see at paragraph 62 her reasons for concluding that a full public inquiry was necessary, fully identified from the outset that it was a condition of impunity that is the context in which the abuse occurred. Impunity is an important aspect when one is considering breaches of fundamental rights, because that necessarily requires any investigation, not simply to look at the actual symptoms of the failure, i.e. the abuse and mistreatment, but its causes. And where it's concerned with impunity, that requires consideration of the wider policy, wider law and policy and regulations in which that abuse occurred. Mrs. Justice May recognised at paragraph 62(4) that the context of immigration detention itself was an important factor in understanding why Article 3 ill treatment occurred in this context. She says, detention under these conditions is diminishing and depersonalising enough, but it is unacceptably degrading and dehumanising where there is repeated and apparent causal abuse on the part of staff employed by the state to supervise and look after such detainees. In making that observation, she recognised that immigration detention itself has peculiarities that render it more likely to expose individuals to ill treatment than other forms of detention, where the regulation and control of its power, of its exercise, is much more constrained. That's also been an observation made, for example, by Professor Bosworth in her examination of the medical evidence. And so looking at immigration detention, its nature and the constraints upon it is an integral part of understanding why inhuman and degrading treatment may well have occurred in the context not just of physical abuse, but of wider mistreatment as a result of a failure to properly identify and manage severe mental illness. So when one starts from the premise that you are extrapolating from the experiences of individuals, we respectfully submit, if that's your starting point, as it should be, then there's no disputes between the core participants and the Home Office, for example, in that regard. Then it's absolutely clear that a central element of the Article 3 issues in this inquiry are intrinsically linked and related to detention, the wider detention policy and its application, yes, at Brook House, but there's no circumstances in which what was happening at Brook House is unique to Brook House, and it reflects the wider systemic issues that have been identified on a number of occasions by previous investigations, some recently preceding this inquiry. Similarly, when one looks at the other individual cases, so Mr. IA, for example, whilst he also was subject to physical violence and assault, his Article 3 claim is not limited to that form of mistreatment. He also bases his Article 3 claim on the fact that he was unlawfully detained, and to that extent the Secretary of State has already conceded that his detention was unlawful, and that detention and the conditions of detention not just exacerbated a pre-existing mental illness, which is Mr. MA's case, but in fact caused serious mental illness. And on that basis, he alleges that he was subject to Article 3 mistreatment. It's both the detention itself and the conditions of detention that are at the core of his credible Article 3 claim that this inquiry is going to investigate. Similarly, Mr. KK, as an individual with severe mental illness who challenged his detention on the basis that it was unlawful and in breach of the adults at risk policy, caused serious deterioration in his mental health and exacerbated to a high degree suicide risk. It's those factors, not any form of specific violent mistreatment which occurred elsewhere, that are the basis of his credible Article 3 claim. In both KK and SR, the Secretary of State has settled their civil claims, but in each civil claim, they alleged not just a breach of Article 3, but intrinsic to that breach, that it was conducted in the context of unlawful detention. So if one is going to start from the basic facts of these cases, and your inquiry is going to be within the parameters of the Article 3 mistreatment that is alleged in this context, then it is inevitable, we respectfully submit, that you are going to have to look at immigration detention, its context, the law governing it, the limits that there are in terms of regulation and policy, because that is intrinsic to the Article 3 claim that they make. In that respect, and certainly from the perspective of medical justice, they have identified as part of the reason for seeking to participate in this inquiry, their extensive experience and evidence that they wish the inquiry to hear, that these individual examples reflect systemic failure at a national macro level, both in law, policy and practice. And that critically, and I think this is important to emphasize, when Ms. McGahey says what the task of the inquiry is, to identify what happened and learn lessons, that's missing out one critical key stage in this process. And that's the question, why did this happen? In order to answer the question, why did these events occurred? Why was Mr. MA, Mr. IA and Mr. KK subject to treatment in the form of detention, which exacerbated and caused suffering because of the impact on their mental health and the inadequacy of the medical treatment and care that they received? That will inevitably require this inquiry to ask whether or not the immigration detention law and policy played a role in understanding why that happened. If we don't understand why, we're not going to be in a position to properly learn the lessons and to end the recalcitrant practices of both the Home Office and its contractors that sequential inquiries have identified but failed to remedy to date. And it is notable that in each and every PPO investigation that has been undertaken in respect of abuse scandals over the decades, identified by Mr. Shaw, in particular in his evidence to the Home Affairs Select Committee, why has that not resulted in any change? Is his investigations have not considered these precise questions. They have looked primarily at operational matters on the ground. You cannot begin at this stage to exclude systemic issues. And when one is concerned with matters that go beyond the temporal limits of the Brook House investigation and outside of Brook House, that's what you're concerned with. It's the system, as opposed to simply the operational implementation of the system. And it's that has been missing, at least in part, from the previous investigations that we know full well have not resulted in the sort of institutional changes that are necessary to remedy serious mistreatment and abuse. So we say, in order to address the why question, certainly from the perspective of systems, it is inevitable that you will have to look at the practices in the way that we have submitted. And it is important to recognise that when you're considering whether there has been breaches of Article 3, the obligations under Article 3 are threefold. They are first and foremost to ascertain whether or not there was in place an adequate and effective system. That system must include law, regulation, policy and practice, as well as an operational duty, which is what happened on the ground, what happened in the individual case. Was there a failure of systems? And then, of course, there's the investigative duty. But one has to start from the premise that the first question for this inquiry, when it comes to decide whether any of these credible Article 3 claims are in fact made out and established, it will be to ask the question, has there been here a systems failure? Is there inadequacy in the overall system? Because if you don't do that, then you're not properly addressing the key obligations that Strasbourg has identified in effective implementation of Article 3. It is also to be noted that of all those previous, of those most recent investigations that didn't look at the situation at Brook House, but looked at some of the consequences, each one of them has identified the legal regime as an important aspect of understanding the failures and the problems that have occurred and recurred within immigration detention. So, for example, the Joint Committee on Human Rights, when it considered immigration detention last year, it identified inadequacies in the legal system, in the legal framework, as contributing to the situation as we describe it of impunity and of repeated unlawful conduct and abuse by the Home Office and in the context of detention by contractors. So that's what the JCHR identified. They said and made a recommendation that it was necessary to have greater restriction on the actual power to detain, that the open-ended nature of immigration detention needed to be addressed, and concluded that it needed very much more statutory provisions to regulate the power and to put a time limit on it. That's not to say, and it's not part of any core participants' intention, that this case is that this inquiry is about time limits. It absolutely is not. But one cannot exclude, if one is seeking to identify why this abuse occurred and learn lessons from it, disregard and not start from the premise that the legal regime, with its inadequate statutory restrictions contrasting with all other forms of detention, and its open-ended nature, do not impact upon the operational implementation of decisions and the treatment of detainees, in that what we would respectfully submit often is a legal vacuum. The Home Affairs Select Committee came to the very same conclusion, that the legal regime was inadequate, was not sufficiently robust to regulate this important power and to limit abuse within it. And they too recommended more detailed prescription in the statutory scheme and a time limit. Obviously, when Mr. Shaw looked at these matters, he was not, it was not part of his remit to look at the legal framework overall, but of course he did focus on policy, and he identified substantial inadequacy and weakness in the existing policy relating to, in particular, those suffering from serious mental illness, and identified important deficits and changes that were implemented as a result of the adult at risk policy. He did that on a generic basis, not of course limited to any particular IRC, because that is a national policy that governs all IRC, or all decisions to detain, irrespective of the location of the detention. And so again, if one is going to build upon the investigations that have taken place, or the reviews that have taken place so far, one should take into account that the two parliamentary committees that have considered this, and Mr. Shaw, both in 2016 and 18, have focused on the legal framework, the wider immigration detention policy, and have based their concerns and their recommendations on the compelling evidence, not just of isolated failures over a very short period of time, but systemic failure, as being relevant to both understanding what is going wrong and as a key basis upon which to determine how things should be improved in the future. The other practical reason as to why it will be important to look at these wider issues is to understand that if you do have a detention centre which is accommodating significant numbers of highly vulnerable individuals who, in accordance with the law and policy, should not in fact be in detention, and present challenges, demands and needs that simply cannot be met in that environment, that may well assist you to understand how individuals faced with dealing with people whose, in particular, mental health or suicidal ideation isn't being properly managed, how that can itself lead to inappropriate treatment. One very obvious and simple example is that it is a recurring theme of many of the Article 3 cases that the courts have identified, that individuals are segregated. And segregation is used as a primary means of managing significant mental health problems and behavior and symptoms. One only has to recognize that if you have no other effective means of managing mental health problems, because this system is not there and not designed to manage those with serious mental health problems who are at risk of particular harm, they shouldn't be in detention at all, why it is that wholly inappropriate, and we would submit unlawful, action is taken to segregate, sometimes for prolonged periods, individuals whose mental health actually requires them to be released rather than to remain within detention. And so we submit that in order to understand how some forms of practice have developed, you cannot separate that from the fact that these are individuals who should not be in detention at all. And in addition to that, if you are considering, as we all acknowledge is critically important, staff culture and institutional behaviour, then it is essential that you look at that conduct in the context of the legal policy and regulatory framework as at least a starting point for understanding how staff culture, institutional practices develop and are allowed to continue, even though clearly inappropriate and abusive. It is, from Ms. McGarhy's observations at the outset, fully recognised that the inquiry will need to look at, for example, safeguards and failure of safeguards, Rule 34 and 35 being critical safeguards in the system, they're part of each of the individual CPs that I represent, a key part of the failure of identification and the continuing detention of them, because those processes did not identify them as vulnerable and therefore unsuitable for detention. If, as is in agreement, that's going to be an important part of the inquiry's investigation, then again, we cannot see how that's going to be separated from the well-established evidence that there is systemic failure in respect of those key safeguards. It's not in any way limited either temporally or locationally to Brook House. That's well established. And again, it wouldn't be building upon previous investigations, in particular Mr. Shaw, if one were going to ignore the fact that this is a systemic problem that goes beyond the time and place at Brook House. And it's important to recognise in that context that the significance of systemic failure in Rule 34 and 35 is because it results in a failure to properly apply detention law and policy. Rule 34 and 35 are the key reporting mechanism, the key interrelationship between the detention centre, contractors, and the Home Office in ensuring that those who are detained are lawfully detained in accordance with general national policy. They don't exist in a vacuum. They bite because it's the Secretary of State's general policy not to detain those who are particularly vulnerable to harm in detention. So one cannot separate out what on one view might look like an operational matter, safeguard, Rule 34 and 35, from the overriding policy considerations. And again, the interrelationship between the failure of Rule 34 and 35 and detention in breach of policy is not an isolated incident, it's systemic. And it will therefore require the inquiry, if it's properly going to look at those matters, as everybody's agreed it must, to have to look at the wider detention context and the wider evidence of systemic failure in respect of those two critical matters. We would finally say, in respect of any decision that is taken at this point, that, as Ms. McGahey makes clear, all are agreed that one has to operate flexibly and go where the evidence takes you. We say it's clear already where the evidence takes you and does require you to consider the matters that we've identified. We would certainly say at this stage it is far too early to take an approach that excludes these lines of inquiry. We do not yet have disclosure made to the core participants. We do not yet have any form of extensive witness gathering. Our clients haven't, the core participants have not yet provided their evidence, and it's not intended that that will be done until the new year. We do raise a concern, and it's another matter that we'll follow up in writing, about the method in which their evidence is proposed to be obtained. But for these purposes, it has not yet been obtained. And so to embark upon a strategy of excluding from consideration these matters, we say would be a fundamental error and a mistake. We would also observe and submit that in the submissions of the Home Office and G4S, there is reliance upon the delay in the pursuit of this investigation as a reason for limiting its and narrowing the scope of the inquiry. We say that's fundamentally wrong. It has been our concern from the outset that as a result of the prolonged delay in this inquiry getting up and running, that the casualty of that would be the scope and impact and effectiveness of the investigation itself. It cannot be, and this inquiry should not go down the route of narrowing or seeking to narrow its scope and exclude these matters, because it is concerned now that it will prolong further the time that it takes to properly investigate these matters. And we would urge you not to take those factors into account, but to proceed as we have submitted on the basis that it is clear, when you properly analyse the individual core participants' cases, that the mistreatment, not limited to physical mistreatment, although of course that's very important, but is not limited to physical mistreatment, and directly engages the detention, the conditions of detention, and the impact upon the individuals in a long established line of authorities that recognises that that does give rise to arguable Article 3 claims. So those are the submissions that we'd want to make in support of why we say that the matters we've relied upon are plainly and squarely within both the terms of reference and derived from the individual facts of the core participants' cases, certainly as they present themselves clearly to us at this stage. The only other matter that was raised by G4S was whether or not the inquiry should consider the efficacy of any changes that have been made or are proposed to be made as a result of the Panorama programme. And we have submitted in writing, and we reiterate that to the inquiry, that it would fundamentally reduce any usefulness and effectiveness of the inquiry if it didn't consider whether or not such changes that have been made have how they are operating in practice, and it would seriously undermine the usefulness of the inquiry if that task wasn't undertaken. We would also submit that it is an important part of this inquiry's remit to consider how the Home Office have responded and other state participants have responded to these kinds of abuse scandals, critically because of the identified failure to result in any enduring change and to learn lessons from previous investigations. That was a matter, as I've indicated, that was of critical concern to Mr. Shaw. It was identified by Mrs. Justice May as a reason why this inquiry, unlike previous PPO inquiries, needed to be a full statutory public inquiry with greater powers to carry out a robust forensic examination of the justification of what happened and why. And so we would respectfully submit that this inquiry would miss a very important part of its task if it were not closely scrutinising and subjecting to analysis whether any of the changes that have been made or proposed to be made would in fact result in addressing the underlying problems and ensuring that this dangerous practices and abuses exposed by the Panorama footage are not repeated. If I could just take one moment to see if there's anything else to add, and then I'll conclude there.
Of course, yeah, please do. Thank you.
Ms. Harrison, would you like a couple of moments to talk to your juniors who are representing all your clients and your instructing solicitors?
If I could, that would be helpful. That'd probably be easier. Yes.
Madam, would it be possible perhaps for us to take a break for 5 minutes?
Absolutely, yeah.
Would that be enough time?
Yes, that will be fine. That will be adequate. Thank you.
Okay, we'll reconvene at 11. Thank you very much.
It still says recording live on YouTube.
Thank you. Welcome back, everybody. Ms. Harrison, did you have a chance to speak to your client's junior counsel?
Yes, I did. And there's just one additional point that I'd just like to emphasize, which relates to the list of issues that we sent to the inquiry some time ago. So there is suggestion by the Home Office and G4S that those lists are too prescriptive. I should indicate that the purpose of providing those potential questions and lines of inquiry, certainly at the point at which it was done on behalf of MA, it was in order to inform what was, as we saw it, the scope of the inquiry based on the terms of reference. It wasn't to straitjacket in any way, shape the inquiry, but it was to give an indication of what we considered to be, on his behalf, to be the key matters that needed to be addressed. And we do respectfully submit that when you consider those questions and the way in which they were formulated, they start very much from MA's individual case, his individual experiences, and they break it down into what are the key matters, focusing on the decision to detain, whether or not it was compatible with the law and policy, in particular the adults at risk policy, and whether or not the safeguards applied in his case. It's from that, we respectfully submit, that you then can ask yourself, as we sought to do in the second part of that list and Annex 2, the thematic questions, the systemic issues which derive from that. And they do inevitably, we respectfully submit, need to consider wider detention policy and practices in order to identify if this was a systemic issue. And then that leads, we sought to suggest, into who might be the potential witnesses that could properly address those questions. And so rather than being some kind of straight jacket that you should ignore, we respectfully submit that the lines of inquiry that we proposed at a very early stage are a practical and effective way of identifying the aspects of the Article 3 mistreatment in MA's case. What does it show about any thematic or systemic issues in the context of the Article 3 obligation to have in place effective systems and operational methods and practices to avoid unlawful mistreatment, and therefore who is going to need to be asked questions to answer not just what happened, but critically why, as the basis for then making your recommendations in terms of learning lessons. And so we would ask you to continue to take into account that suggested lines of inquiry, and certainly not shut it out or narrow it or exclude aspects of that inquiry that we identified as being important and necessary for effective investigation. Those are all my submissions. Can I just say that Mr. Goodman is now going to make a short submission on behalf of Reverend Ward.
Thank you, Ms. Harrison. Mr. Goodman. Mr. Goodman, can you hear us?
I think it may be the same issue about being
muted.
Yes, so I think you have to do something at your end.
Okay, we can't actually see him on our screen, but just my apologies. Give us 2 minutes and we'll try and solve that.
Hi, apologies. It's Mr. Kett. I've just been told by Mr. Goodman that he's lost the Zoom link and it's been locked out.
Okay, is he attempting to rejoin us?
Yeah, I think he may have been locked out. I don't know whether the engineer needs to
okay
back in.
my apologies to everybody online. If you will just give us 2 moments, we'll try and resolve that and allow him back in. Okay, if you could try again, Mr. Goodman, my apologies for that. Mr. Kett, if you can pass that message to him, please. The room should now be unlocked. He should be able to get back in.
Thank you.
Thank you.
Hello, I think I've been readmitted, Chad. Can you hear me now?
We can. Thank you very much. We can't see you. Would you like your camera to be switched on? There we go. Thank you very much.
Thank you. I think there needs to be a mechanism to readmit, but find out. I wanted to, if I may, Adam Brake, slightly on behalf of Mr. Ward.
We can. Thank you very much. We can't see you. Would you like your camera to be switched on? There we go. Thank you very much.
Thank you. I think there needs to be a mechanism to admit.
Mr. Goodman, if you're connected to the YouTube stream at the same time, it might be that's why we can hear 2 versions of it.
Now disconnected. I had to follow while I was locked up. On behalf of Mr. Ward, I just want to add a couple of points. The summary submission for Mr. Ward is that purporting to exclude matters from consideration in anticipation of the evidence is inappropriate and will be unhelpful for the participants. The preliminary descriptions that have been given by counsel to the inquiry of the kinds of matters that it is contemplated will be excluded are difficult to interpret, and to hold, for example, that wider issues of immigration policy are excluded will simply lead to unnecessary and unhelpful debate as to what that actually means further down the line. Mr. Ward's submission is the proper approach is simply to determine if and when an issue arises that a matter is unhelpful or irrelevant and make that clear when it does. As to the scope itself, it may be helpful to just remind the inquiry of some of the principal learning upon this. So the first passage I'd like to refer to is in the decision of Mr. Justice Jackson in the case of Margaret Wright against the Secretary of State for the Home Department, 2001, EWHC Admin 520. Mr. Justice Jackson held there at paragraph 43 as to the investigative duty under Articles 2 and has been subsequently held under Article 3, the investigation is required in order to maximise future compliance with those articles. And Lord Bingham, in case of Armin against the Home Secretary, 2004 1AC 653, approved Mr. Justice Jackson's description at paragraph 31 of his speech. And he described the purposes of the investigation, the Article 3 investigation, as including that dangerous practices and procedures are rectified. So the inquiry is concerned with identifying dangerous practices and procedures so as to rectify them and ensure compliance in future with the substantive provisions of Articles 2 and 3, and of course also the procedural and investigative duties. Similar position was explained by Lord Justice Sedley in the Court of Appeal in the case of AM against the Secretary of State for the Home Department. It's 2009 UK HRR 973, paragraphs 57 to 60. And he described the purpose of an Article 3 investigation as being to inform the public and the government about what may have gone wrong in relation to an important civic and international obligation, and about what can be done to stop it happening again. And at 58, he held that Miss Justice Jackson's formulation in Wright was correct. And at 59, he held that it's significant in the light of the foregoing discussion that that formulation as to the scope of the duty includes ensuring, so far as possible, that the full facts are brought to light and that lessons will be learned and implemented. Both of these objectives go markedly beyond the identification and punishment of those responsible. They are reflected both in Lord Bingham's explicit reference in paragraph 21 to the particular anxiety which may attend a systemic failure to protect life, and in Mr. Justice Hooper's reasons in the Armin case, endorsed by the House of Lords, for directing the holding of an inquiry. And he quotes, "It is accepted that the victim was put in the same cell as his killer in the Armin case because of systemic failures. Established procedures were not followed, and there is an appalling history at Feltham of a failure to comply with earlier recommendations." Lord Justice Sedley went on to hold our domestic jurisprudence, including the binding decision of the House of Lords in Armin, makes it clear that the investigative obligation of the state may, depending on what facts are at issue, go well beyond the ascertainment of individual fault and reach questions of system, management, and institutional culture. And the last case, which the Chair I hope will find helpful, is the D against the Commissioner of the Metropolis. It's the case about the investigation of the John Warboys crimes. And the reference is 2018 2 Weekly Law Reports 895. And this really puts the matter beyond doubt. There's a lengthy engagement there with the case law. I refer in particular to the speech of the late Lord Carr, SCJ, in which he cites in particular the Biganovich case. And the review of the cases there makes abundantly clear that, in fact, the preponderance of cases on Article 3 have focused on failures in system and regulation primarily, as opposed to the mere facts of the incident. So the question is, does the inquiry need to identify dangerous practices and procedures? And on the basis of Armin and all the case law, the answer can only be yes. It follows, therefore, dangerous practices and procedures must be identified and flaws in them must be rectified. The inquiry's principal function, indeed, is to make recommendations to ensure that they are rectified and that the abuse at issue here does not occur again. And so, just as the investigation in the case of Mr. Armin was expressly required by Mr. Justice Hooper to determine the system failures that meant Mr. Armin ended up in a shared cell when he shouldn't have been, so this case, this investigation, will have to trace through, for example, why Mr. M.A. was put into Brook House and why he was not released upon a medic examining him. And to do that, it will need to trace through how it was that he was never identified properly as being vulnerable and released as a result. It will need to look at why there was seemingly no assessment of the appropriateness of putting him in isolation or segregation, to pick up Ms. Harrison's example. And the inquiry cannot hope to know the answers to all of that prior to examining the evidence and investigating the facts and the system in which these tragedies occurred. It's inappropriate to be making anticipatory determinations on scope that may exclude or limit the ability of the inquiry to ascertain the full facts, to ascertain what went wrong. So just to take a particular example, the inquiry will have to look at the issue of isolation and segregation that Ms. Harrison referred to, particularly in the case of M.A., given his mental illness and that he was subjected to those procedures. To undertake that exercise, of course, the inquiry will need to look at the individual decision by officers responsible in Brook House. That's not in dispute. Of course, it will need to look at the management oversight of those decisions. And of course, it will need to ascertain whether proper processes were undertaken when authorising that decision to put him in isolation. But where it's apparent that the proper processes were not followed in the individual decision, is the inquiry really going to, in anticipation, inhibit itself from looking at whether the detention centre rules which govern isolation and segregation operate effectively? Is it intending to inhibit itself from looking at the policies around the use of segregation and isolation in immigration detention? Is it intending to inhibit itself from looking at how a mentally ill detainee came to be in that detention centre? Will it say, in anticipation, that it's not going to look at why Mr. MA was not released from detention before even being put in isolation? Is it going to inhibit itself from looking at the previous investigations, for example, by Mr. Stephen Shaw or the House of Commons, of the failures to operate and protect mentally ill and suicidal detainees, at the failures of those systems in other investigations? And is it intending not to look at High Court judgments that have highlighted failures over many years? Respectfully, if the intention is in any of those cases not to look at those wider questions, then the inquiry is obviously approaching this matter in the wrong way and in an artificial and constrained way. And so Mr. Ward's submission is that an anticipatory determination on scope is really artificial and unhelpful. The scope of the inquiry is self-evident and apparent. There's no intention to bring in matters outside Brook House. The intention is that the matters within Brook House are understood within the proper and full context of the procedures, systems and laws that have relevance to the abuse that took place there. Immigration policy more widely is the phrase that's been used in Council's note. It's unhelpful, Mr. Ward submits, for the chair to purport to determine one way or another whether immigration policy more widely is to be excluded at this stage. It's too vague a phrase. Of course, the inquiry is not interested in some aspects of immigration policy, but what happens in an immigration detention centre is a manifestation of immigration policy. There's a continuous spectrum of relevance. It's impossible to attempt to draw a line in anticipation as to what is and is not relevant. That will have to be left to the examination of the evidence and case-by-case determination. If parties misuse the process or stray from what's helpful to the core purpose of the inquiry, then control that, but don't purport to close the inquiry's mind before hearing the evidence. Thank you.
Thank you, Mr. Goodman.
Madam, may I invite Mr. Odogwu to make submissions to you on behalf of BB and Gatwick Detainees Welfare Group?
Thank you. Can you see and hear me?
We can, yes. Thank you.
Great. Madam, before turning to scope, it's appropriate to place on record that we endorse and adopt the written submissions on behalf of Medical Justice, SR and KK, dated the 10th of December, on those additional matters of timetabling, witness evidence gathering, the identification of potential detainees, resources, disclosure, and the experts issue. Madam, I note your earlier acknowledgement of those submissions, so I don't propose to develop those further at this time, except to place those on record. I also don't propose to rehearse the submissions on scope that are already before you. They have been detailed and extensive. We adopt the submissions on behalf of MA, Medical Justice, SR, KK and Mr. Ward, and indeed ourselves from our previous submissions. And so it follows, I don't propose to address you, Madam, at length. I have 5 brief supplementary submissions on scope. First, Madam, the position adopted by the chair in the opening statement and the note recognises that the inquiry scope should include the changes that have been made in response to the Panorama documentary and an investigation into whether those changes are adequate. Indeed, the adequacy of those changes were described as crucial in the notice of determination of BB's core participant application. We, of course, adopt that view. Submissions advanced on behalf of G4S, however, suggest that adequacy can be assessed by reference to what the inquiry considers appropriate to remedy any defects without an assessment of their effectiveness in practice. It's unclear from G4S's submission how the inquiry is to go about this theoretical exercise. We note Ms. McGahey has already invited further clarity from G4S on this point. But in any event, we say respectfully that approach is flawed. In measuring the adequacy of any change, that doesn't mean holding an inquiry into exactly how something is not working, but there does need to be some examination of the effectiveness of those changes in practice. Adequacy of systems cannot simply be resolved in the abstract or in theory, as G4S invite you to do. It will require assessing evidence as to its effectiveness, particularly if this is controversial between the core participants. Ultimately, it does depend on what changes have been made. And so essentially, the inquiry is going to have to wait and see and not to make a determination at this stage. The second submission, Madam, addresses the slight difference in drafting of the inquiry's terms of reference from that of the original terms of reference as drafted by the probation ombudsman. This was referenced in the submissions, I believe, from G4S, namely that the phrase "in particular" occurs in the previous sentence in the original terms of reference. We say that essentially makes no difference to the intention of the terms of reference. It was clear then, and it's even clearer now in the construction of the terms of reference as drafted for the purposes of the inquiry, that the areas of focus identified at those subparagraphs 1 to 6 were not intended to be exhaustive. At the very least, the drafting suggests that terms of reference should not be interpreted strictly or narrowly. That is clear, we say, from both versions of the terms of reference. So any submission that there is some subtle change because there is the word "in particular" occurs in the next sentence, we say is misplaced. This leads, Madam, to my third submission, and perhaps it's my most important submission. As identified by counsel to the inquiry in paragraph 4 of the note, all core participants agree with our earlier submissions on scope that effectively the inquiry needs to remain flexible and go where the evidence takes it. But Madam, what does that actually mean in practice? The chair and Ms. McGahey will perhaps be familiar with the funneling exercise that underpins all Article 2 compliant inquests. And that analogy was coined in the Court of Appeal case of Lewis at paragraph 29, which stated, the inquest process can be visualized as a funnel, wide at its opening, but narrowing as the evidence passes down it so as to exclude non-causative factors from the eventual verdict. This principle, Madam, neatly embodies our overarching submissions essentially on scope in this inquiry. We do not disagree that what happened to the individuals who were detained at Brook House during the relevant period will be the focus of the inquiry, that there is no dispute between the core participants on that issue. However, we submit that not only is the funneling approach to wider issues required by the legal obligations that are imposed by Article 3, it also makes logical sense for two reasons. First is, we are having this inquiry because other investigations have failed to address the root causes. This inquiry is the first of its kind, and it's prompted by abuse at the highest and most systemic level. And so this makes the inquiry take on even greater importance to the public and requires a particularly intensive and extensive examination of the wider issues. The second reason why it makes logical sense to adopt this funneling analogy in this inquiry is because to narrow the approach of the terms of reference at this early stage serves only to limit the lessons that can be learned before the evidence has even emerged. and those, in that sense, we adopt the submissions already made on behalf by Ms. Harrison and on behalf of Mr. Ward. My fourth submission, Madam, relates to the paragraph 2 of the terms of reference, which appreciates that the inquiry requires an examination of whether methods, policies, practices, and management arrangements caused or contributed to any identified mistreatment. The point to make is a simple one on this aspect. We submit a possible causal connection is sufficient to trigger the investigative duty into those system issues. This approach is consistent with Article 2, as described in the case of Speck in 2016, the High Court case, which confirmed that a coroner conducting an Article 2 inquest has a duty to investigate those matters which caused, or at least arguably appear to have caused or contributed to death. And that's taken from paragraph 47 of that judgment, case of Speck. In this context, Madam, arguable is one that is more than merely fanciful, and therefore we submit it is a low threshold. And this should be met where there is an issue which requires further investigation, or whether inquiries may reveal a breach, but it's not limited to where there is a prima facie case at the outset before evidence has been heard. And it's also relevant, Madam, that the case I referred to earlier, the case of Lewis, made it clear that there is a power in Article 2 proceedings to leave possible causative issues as shortcomings. Madam, my fifth and final submission is that you perhaps would have noticed from our written submissions and our draft list of issues that we have approached the terms of reference with particular emphasis on the characteristics of the detained person. And that is because whether there has been mistreatment as defined by the terms of reference as treatment contrary to Article 3 depends on all the circumstances, including the nature and context of the treatment, its duration, its physical and mental effects, whether the victim is detained, and the sex, age, and state of health of the victim. So motivation of the alleged abuser of Article 3 treatment is relevant to whether there has been a breach. And so the inquiry is required to take all reasonable steps to unmask any discriminatory or indeed racist motive in either any incident that's been complained of, and also policies, practices, and management arrangements to establish whether or not there has been any prejudice which may have played a part. And that's why there is the broad culture of issues and system issues need to be examined and understood as part of this inquiry. Madam, you posed the opening question of how events outside Brook House or the relevant period will assist with answering the questions of what happened and what lessons can be learned in the future, will effectively dictate the question on scope. And it follows from my submissions that this inquiry must consider the wider system issues that govern policy, practice, and institutional culture at a high level, and not limiting it to Brook House when considering those questions that you've posed, which go to the issue of mistreatment in individual cases. Because the wider systemic issues and the individual cases are inextricably linked. You can't divorce the two. And to do so will be artificial, and it won't assist this inquiry. Madam, those are my submissions. I said I'll be brief, unless I can assist further. Perhaps, in fact, I'll take one moment just to check with my instructing solicitors.
Thank you, absolutely.
I'm very grateful, Madam, that no further submissions at this stage. Can I just ask, so I'm waiting to hear back from my colleague, Mr. Jesse Nichols. So perhaps if there is anything arising, I may have the opportunity to address a discrete issue.
Absolutely, no problem. Thank you very much.
Thank you.
May I invite Mr. Blake on behalf of the Home Office to address you next?
Thank you.
Thank you very much. I don't wish to take up too much time with oral submissions today because we've already filed detailed written submissions and because the approach that's already been proposed by the inquiry is frankly very sensible, appropriate and realistic. It's important to keep in sight what the inquiry was set up to achieve. We've become very used to vast public inquiries, often over many years and costing millions of pounds. The Brook House inquiry, however, was set up as an investigation, a targeted investigation into mistreatment that occurred at Brook House between April and August 2017. It's by no means a small investigation. We've heard already today about the vast disclosure exercise that's already been involved, but it is a targeted investigation. It's by looking at that snapshot at Brook House at the relevant period that wider lessons can be learnt that can apply to the immigration detention estate as a whole or in the future. But at the heart of this investigation are not broad political questions, but individuals. And it's an investigation into what happened to those individuals at Brook House at the relevant period. And it is going to be establishing whether any individuals were subject to mistreatment contrary to Article 3. Now, I've heard the submissions of Ms. Harrison, Queen's Counsel, this morning. The decision to detain itself can't, of course, be a breach of Article 3. That's not what Mrs. Justice May said, and I don't actually think that that's what Ms. Harrison is saying. We've set out in our submissions the legal threshold, and that's a decision to be taken in each case. The inquiry will be establishing whether in a particular case, whether there was treatment which takes it beyond that threshold, and that includes testing the accounts of individuals as to what is said to have amounted to mistreatment in their case. Mrs. Justice May did not, in fact, make any findings whatsoever insofar as their treatment was concerned. Mr. Goodman and to some extent Mr. Adogru cited quite a few cases to us this morning. It's not possible, of course, without pre-exchange of authorities in advance to make any detailed submissions on those authorities. But what I do say is that in cases where there has been a death, it's very clear that a death has happened. In an Article 3 case, the first step must be to establish whether there has in fact been mistreatment. That is the starting point. And in those cases where mistreatment has been found to have occurred, then finding out what happened and what can be learned from that. We've set out our submissions in terms of the terms of reference at paragraphs 4 to 13 of our written submissions. In short, every paragraph in the terms of reference tracks back to paragraph 1, which is the investigation of mistreatment. The Home Office wholly supports the approach that has been indicated by the inquiry, whereby the starting point is the mistreatment of those who are detained and looking into their reported experiences. All further investigation must concern those cases where mistreatment has been identified. Using the language that was used, in fact, in those High Court proceedings by MA and BB themselves, the investigative obligation is inextricably linked to the specific nature of those breaches. G4S in their written submissions today have described the investigation into mistreatment of those who were detained as the touchstone of the inquiry's purpose, and we would absolutely agree with that. As far as issues other than establishing what happened to those individuals are concerned, you, Madam Chair, are an experienced investigator, and we don't propose or seek to impose a detailed list of lines of inquiry of witnesses. All the core participants have submitted that the inquiry needs to be flexible and be led where the evidence takes it. It's of course sensible to draw up a list of issues, and we've addressed that at paragraphs 14 to 26 of the Home Office's submissions. We endorse the inquiry's provisional list, subject to the possibility that the evidence might render some of the issues unnecessary. We can't yet know whether or not that will happen, and that is the funnel that we've just heard about. In respect to wider policy issues and lesson learned, as I began my submissions by saying, and the constant theme of the Home Office's submissions, is that the inquiry must always keep its eye on the individuals found to have been mistreated and the policies, procedures, and practices that applied to them. If and to the extent that national policies, practices, and procedures played a direct role in that mistreatment, then so be it. They can and should be investigated. They're certainly not being ruled out. But the inquiry isn't the correct forum for broad political questions, and it must focus on the issues which are central to that mistreatment. Finally, and related to that point, as various core participants have made clear at the last hearing, in order to be effective, the lessons that are learnt need to be meaningful and they need to prevent recurrence as soon as possible. We know that the inquiry has already conducted a lot of work behind the scenes, and we're certainly not relying on some alleged delay to limit the scope of the inquiry. But practically speaking, looking at decades of practice or wide political themes, as suggested by some of the core participants, would inevitably undermine that key aspect of the inquiry, which is to make a timely diagnosis. That would be the case, frankly, whenever the inquiry began, and certainly the time that it's taken to set up the inquiry and to conduct all the work that you have already conducted certainly isn't being used by the Home Office as some reason to cut out or narrow the scope. We're simply saying that those very broad political themes and looking at decades of practice certainly is not achievable. I don't have any further submissions to make. I can just double check. Nope, nobody has corrected me, so I'm happy to leave it at that. Thank you very much.
Madam Mayor, I invite Mr. Sharlin, Queen's Counsel, to address you on behalf of G4S.
Thank you.
Good morning, Chair. Can you hear and see me?
I can hear you. I can't see you. Maybe at our end. If you would just give us one moment, we'll try and correct that for you. Apologies.
I think you can now see.
There you are. Thank you. Please go ahead.
Thank you very much, Madam Chair. I'm going to make brief oral submissions, take into account your opening comments. I'm not planning to repeat my written submissions that you've indicated you've already read. I will, of course, address the point made at paragraphs 12 to 13 of Counsel to Inquiry's note that we've been asked to comment on. Madam Chair, the purpose of this inquiry is, of course, to discharge the state's investigative obligation under Article 3. As Mrs. Justice May explained in BB and MA's judicial review at paragraph 61, in the context of considering whether a power to compel witnesses was necessary, she said, I've borne in mind also that the Article 3 investigation can only be parasitic on alleged substantive breaches of the article, and that its efficacy must therefore be assessed by reference to such breaches alone. Now, my learned friend, Ms. Harrison, took you to various extracts from Mrs. Justice May's judgment, including paragraph 24, where the various allegations of breach of Article 3 were set out. However, there is nowhere in the judgment that Mrs. Justice May accepts that all those matters raised do amount or potentially amount to Article 3 mistreatment. Indeed, if you look at Mrs. Justice May's conclusion, particularly paragraph 61 and 62, the focus is very much on alleged physical abuse. It is not looking at wider issues about whether the particular individual should or should not be detained. And of course, Mrs. Justice May's judgment must inform this inquiry's approach to the terms of reference, which are there to discharge the state's Article 3 investigatory obligation. I would agree with my learning from Mr. Blake. The focus of the inquiry must be on the alleged mistreatment, contrary to Article 3, of persons detained. That has to be the starting point. The inquiry must consider whether there is credible evidence of mistreatment contrary to Article 3 in relation to a particular detained person. If there is such credible evidence, the inquiry must go on to consider whether there actually was mistreatment of the detained person contrary to Article 3, and if there was, what were the causes of such mistreatment, and what steps must be taken to ensure that such mistreatment does not happen again. If, however, there is no credible evidence of mistreatment of sufficient severity to breach Article 3, that is the end of the inquiry in relation to the detained individual. I would echo my learned friend Mr. Blake's comments in response to the reliance by various parties of Article 2 jurisprudence. You cannot just merely apply the Article 2 jurisprudence to Article 3 cases because different considerations arise. The temporal scope of the inquiry is clearly laid down in the terms of reference, 1st of April 2017 to the 31st of August 2017. It's not the role of the inquiry to investigate the existence of credible evidence before the 1st of April 2017 or after the 31st of August 2017, as some of the core participants appear to be suggesting. It is important to note that part of the terms of reference address the issue of your report. The terms of reference state that it is expected the inquiry will make its best endeavours to complete work and produce a final report to the Home Secretary, setting out findings of fact and recommendations within 12 months, i.e. by November 2020. It is clear that this timetable envisaged a focused and narrow inquiry into alleged mistreatment contrary to Article 3 of detained persons at Brook House only over the 5-month period. The very broad scope of the inquiry suggested by BB, MA and certain other core participants goes beyond what is necessary for the state to discharge its investigative obligation under Article 3. Indeed, if the suggested approach was adopted, it's likely to give rise to a significant risk that the inquiry will fail to discharge such an investigative obligation because, as the Chair is well aware, there is a requirement that such investigations must be completed promptly. And the more broad the inquiry goes, the longer it will take. Madam Chair, I now want to respond to paragraphs 12 and 13 to Counsel to the Inquiry's helpful note, where she picks up and quotes a submission from our written submissions, where it says G4S contend, however, that the inquiry should consider the adequacy of those changes, quotes, by reference to what the inquiry considers is appropriate to remedy any defects and not pursuant to any additional assessment of their effectiveness in practice. It appears that this has been somewhat misunderstood. The point we're making here is ultimately one of focus. We accept that the inquiry shouldn't, of course, be blind to whether a particular reform is effective or not. But our point is that when the inquiry considers changes that have been made, it can only do so as a means of addressing the question of what recommendations should be made to remedy defects arising from the inquiry's findings. Any assessment of subsequent changes can only be instrumental to those ends and must be confined to that purpose. It's about ensuring that there isn't a wide-ranging inquiry into the effectiveness of Reform X, which may have multiple purposes when, for example, only one of them is relevant to a defect relevant to this inquiry's terms of reference. Any assessment that goes wider than a reform's relevance to a finding made by the inquiry lies outside the terms of reference. The terms of reference have a specific temporal period, and the inquiry should avoid the risk that any examination of the effectiveness of reforms unlawfully widens the temporal scope of the inquiry by the back door. What the inquiry should not be doing is carrying out an investigation of what took place in a specified period in 2017, per the terms of reference, and then effectively doing the same extensive exercise in respect of, for example, 2018, so as to assess fully the effectiveness of remedial steps subsequently taken. The crucial point is that consideration of the remedial measures is relevant to the adequacy of those changes to remedy defects identified by the inquiry and not an additional assessment of effectiveness, i.e. they must be done properly within the terms of reference and not something additional to them. Madam Chair, those are my submissions. I've just checked my email and I don't think there's anything further I need to add or clarify. I'm very grateful. Thank you.
Thank you, Mr. Sharland.
Madam, before I go on to other core participants, I'm sorry, I should have come back to Mr. Adogwu and asked whether there was anything else he wanted to add, having conferred with Mr. Nichols.
You probably can hear me. I'm not sure if you can see me.
We can hear you, yeah.
Yes, nothing to add. I'm grateful.
Thank you very much.
Thank you. Madam, could I invite then Mr. Bunting on behalf of the BBC to address you?
Thank you.
Madam, the BBC have no substantive submissions to make in respect of scope, and I'm very sorry for not confirming that in writing by the agreed date.
No problem. Thank you very much.
Ms. Dobbin, on behalf of Her Majesty's Inspectorate.
Madam, I don't know if you can see me.
We can see and hear you, yes. Thank you, Ms. Dobbin.
Well, Madam, we don't have any further submissions to make. Thank you.
Thank you very much.
And lastly, Mr. Dixie on behalf of the IMB.
Chair, good morning. Likewise, we make no substantive submissions on scope.
Thank you, Mr. Dixie.
I wondered if it was possible just to make some short submissions in response to the G4S submissions on the significance of the findings in MA.
Yes, please go ahead.
Just in terms of principle, it was clear and it was common ground between the Secretary of State and the individual claimants that there was no substantive difference in principle between the obligations, investigative obligations under Article 2 and 3, and you'll see that from the judgment that there was common ground about those about the approach. Secondly, it is clear that Mrs. Justice May was well aware that the allegations that form the basis of MA's Article 3 claim are in no way limited to the physical abuse. And you'll see that from paragraph 24, which I showed you to. She described that the events revealed by the Panorama programme were merely the tip of the iceberg as far as he is concerned. And then she sets out the matters that were relied upon in paragraph 24. And when she comes to her conclusions, she makes clear at paragraph 63, having set out key factors that I showed you in 1 to 4, that the allegations made by MA and BB go much wider than events shown in the Panorama programme. The full extent of Article 3 abuse said to have been experienced by both claimants needs to be investigated. There's no circumstances in which Mrs. Justice May was limiting the need for an Article 3 investigation to the specific incidents of mistreatment in the form of physical abuse. And as I've sought to emphasize and to show you, his case very much focuses, in addition, on the detention, the conditions of detention, and the impact of those conditions on his mental health. And insofar as Mr. Sharland seeks to suggest that the description that were the key factors that led Mrs. Justice May to conclude that a full inquiry was required at 62, one only has to read what those were when she emphasised in paragraph 62(1) the egregious nature of the breaches, the multiplicity and regularity of the abusive events, and the openness of the activity within the units, as well as the fact that individuals were able to act regularly without complaint or criticism from other staff or detainees, or without other supervising staff and or monitoring bodies picking it up. So whilst of course that focus on the events that took place within Brook House itself, the gravity of the breaches and the nature of them, and as I indicated at the outset of my submissions, the fact that they occur within a climate of impunity is the critical reason why it's going to be necessary in answering not just what happened, but why it happened, to look at the systemic context in which this serious abuse occurred. And for all the reasons that we submitted, it was absolutely clear that Mrs. Justice May recognised, and it's a foundation of her judgment, that it was going to require consideration of systemic problems, not simply operational matters on the ground. And for those reasons, we say that Mr. Sharland was wrong and incorrect to suggest that anything that is found in the judgment would justify in any way narrowing or limiting the scope. And of course, nothing that would have to have been apparent from the terms of reference, and contrary to his submissions, those terms of reference amply cover and must cover the systemic issues and context in which this abuse occurred. Those are my only additional submissions on that judgment.
Thank you, Ms. Harrison.
Could I very briefly just address one matter, and that's the scope of agreement from the MA and BB High Court proceedings?
Please go ahead.
Yes. The agreement was as to the very broad principles that the investigative duty incorporates, such as an effective investigation, a prompt investigation, learning lessons. But the particular submissions that were put at today's hearing in respect of the similarities between Article 2 and Article 3 weren't matters that were considered by the High Court and weren't matters that were agreed there. Thank you.
Thank you, Mr. Blake. Okay, I believe the next on our agenda is just Ms. McGahey. Can I ask you if you have anything else you wanted to add about the timetable for the inquiry?
One final matter. The intention is, as I mentioned at the outset, for the inquiry to start taking witness statements in January. that will be a process that continues over the coming months. The current intention is that this inquiry should start its oral hearings on around the 14th of June of 2021. It is very difficult at the moment to say how long those hearings may take. We will be dependent on a number of factors. Firstly, the number of witnesses that you decide to call. Secondly, the COVID situation, and whether you take the view that certain witnesses really must be called face to face if at all possible, or whether it's possible to call them by video. At the moment, the intention is that we'll sit from mid-June into July. Whatever happens, the inquiry will not sit in August. It may continue with its hearings in September. So I hope that that's some assistance for those who have to plan their diaries in advance.
Thank you. Okay, I believe that brings us to the end of this morning's agenda. So just to remain for me to say thank you very much for all of the submissions this morning, all of which I've listened to carefully and I will now consider further, and I will then be issuing my ruling on scope in due course. Thank you all very much.